YNW Melly trial takes a turn after judge confronts the prosecution over misleading claims.
The investigation is still open.
But that could be forever. I hate to interrupt lawyers, but that could go on forever. So what's the plan, sir, if you don't mind letting me in on this? Now that I've special ordered 750 jurors in September, are you all planning on arresting Ms. Liberty 10 days before the trial starts?
I can't disclose that at this point.
But the state hasn't turned anything over.
Because we're not intending to use it. It's not going to
That's not
affect
what
Mr. Demons'
3.220
case.
says. It's not what you intend to use.
YNW Melly's been sitting in a cell for over 2,200 days, and his retrial for double murder still hasn't happened. The state is seeking death penalty over claims he killed two of his closest boys, YNW Juvie and YNW Sack Chaser, back in 2018. The first trial ended in a mistrial, and ever since, it's been delay after delay. But now, Melly's legal team is done playing games. They were back in court recently, pressing the state on a witness tampering charge.
The state should have revealed a year ago that, in fact, Miss Liberty's Apple accounts had been searched. They did not do that. The case law seems to be very clear also, Your Honor, that we don't know what they have. What we know is that they've seized Miss Liberty's Apple accounts, but when asked whether there were other search warrants, the state still has not revealed whether anything else of Miss Liberty's accounts have been searched. They did tell us that, in fact, that no other attorneys' accounts were searched. But as to this, in that, are there comments made about our trial strategy? Are there emails? Are there communications, text messages about our trial strategy?
Am I correct? The state has not made any supplemental discovery disclosure regarding any of these materials?
Correct.
So I presume that means you're not going to use any of this at the trial because
Correct.
You've had an obligation to do so and
Yes.
you haven't done it.
And that was my comment to the court.
If you're not going to use any of it at the trial, since Mr. Demons is entitled to heightened due process because of the penalty that's involved here, you haven't charged Ms. Liberty. You've had over 17 months to do, 15, 16 months to do so. Despite your all's position, I've previously found that it's not an ongoing investigation because you haven't done it. Now you're telling me there was no materials involved that were turned over to the state that even warrant you supplementing discovery. So if that's the case, what is the harm with me granting the number 2 request that you all just copy everything that was given to you and give it to the defense so they can see what it is? What's the harm?
So despite what the court feels is no longer an open investigation, it does remain an open investigation. I have met with the detective. The investigation is still open.
All right, well, but that could be forever. I hate to interrupt lawyers, but that could go on forever.
I can tell the court the case is actively being worked.
Well, that doesn't mean anything.
And on top of that, well, because obviously I can't disclose to the court exactly what's going on.
So what's the plan, sir, if you don't mind letting me in on this? Now that I've special ordered 750 jurors in September, are you all planning on arresting Ms. Liberty 10 days before the trial starts?
I can't disclose that at this point.
Well, okay. So my finding over your objection and the way I'm going to proceed forward is that there is no ongoing investigation. So that's the way I see it.
So she has what the state, she probably has more, honestly, but she has what the state has.
If that's true, the harm in me ordering you to turn it all over, so then she'll have 2 copies of what she already has, is what?
I'm telling the court there's been no seizure and it remains an open investigation.
Let's say you're right, which you're clearly not, but let's say you are. He has to decide who he wants his lawyers to be. We keep having the same discussion.
And
how many trials do you want?
And I'm protecting my open investigation, Your Honor.
No. I understand what you just said, but there's no record evidence of that.
I know, I'm proffering to the court.
Proffer's not going to do it, sir.
And again, Judge, I still have not completed all my work in terms of
You're telling
responding
me
to this.
if I order you all to turn it all over to me, and I review every single part of it, you believe I'm going to determine that nothing qualifies under 3.220, nothing they're entitled to prepare for trial?
Judge, we're not using anything.
That wasn't the question.
I understand the court's question. I'm telling the court I don't have access to everything because obviously there's a filter team in place.
You don't know.
Right, but I don't know because I'm not entitled to know, nor will I know.
But the state hasn't turned anything over.
Because we're not intending to use it. It's not going
That's
to
not
affect
what
Mr. Demons'
3.220
case.
says. It's not what you intend to use. That's their standard.
But that's what
they have to turn over
the
what
case
they
law
intend
and
to
the
use.
statute.
You have to turn over everything that you know about.
If it intends to be used at trial or it has any material bearing. And based upon what we are aware of and what has been turned over, it is not. BSO was not noticed of this hearing. They are the investigators in this case. They are the ones in material possession of these documents. They're the ones that actually know more about the investigation than we do. And I feel they have a right to be heard as well, because in some of my initial research, when I was looking at things like public records requests, the lawsuits always involve the sheriff's office
This
versus
isn't a
the
public
defendant.
records
I
request
understand,
lawsuit, sir.
but I believe that our sheriff's office also has standing.
You're 3 for 3. I don't agree with anything you said.
Judge, again, I still haven't had an opportunity to fully address the motion, which is why I was asking for additional time.
Okay, over your objection.